9. The second year. When I met you at this time a year back, you were apple green. The green, as I look over your expectant faces now, seems somewhat to have paled. And you seem larger. If one should bite you now, he would expect to find some signs of juice. Sour, quite sour, doubtless. But still juice. Clearly, you hold some promise. But with that gain in size and juiciness, under the benignant sunshine of the faculty have come responsibilities. And these responsibilities I would recall to your attention. Last year, it was a question of what you had a right to expect from the second year class, and of how to go about realizing those expectations. This year, it is a question of what the first year class has a right to expect from you, and of your job in making real those expectations, whether or not these new cubs have the sense to run you up a tree and bay for information. I want to remind you that a school is not made up of faculty, and that a legal education is 9/10 and upwards a product of the student body. I want to remind you the incoming class is, if possible, even greener than yourselves were once. I want to remind you of the strangeness with which you gazed upon a casebook and wondered what in hell a brief might be, or what you were to do with the cases. Of your utter lack of knowledge of the meaning of the law library, or of how to take the first step in its utilization. Of the days when Arthur Corbin was only a name and a law review an unknown concept. When law examination was a stark specter, vastly terrible because it had not been experienced. I want to remind you, too, of the comfort that came when you did get some advice from somewhere in one of your perplexities, and of how much easier the first 4 weeks would have been if that advice had been frequent and ready. In a word, I want to call upon you to pick up your burden and to take your part in making the school for the incoming class a school and not a prison, a road to education and not a road to despair. There is nothing to make you do it. But if you do, this much at least I promise: that what you said about making clear to another man, you will know vastly better yourself when you are through. That the time you spend on him will deepen your own understanding of the law, and that only in the measure that the practice of cooperation is built up or kept up, will the first year class, or you yourselves, or the classes to follow, have a school which has a reason for existence. There is another reason why you must perform upon the first year class. They come into these sacred halls of which you have become the yearling priests. They stink of laity. They must be cleansed. They must be quickly cleansed, or all of us will be profaned. Gird up your loins, then, my beloved, and descend into the pools. In each left hand a pot of legal germicidal soap, each right fist brandishing a foot-long brush of dialectic. Seize these new woolly lambs and scrub them for the law. Scrub them with love, but above all things scrub them. Then raise them as the young things should be raised. But apart from this plea on behalf of the neophytes and of our order, there are things to meditate upon in regard to your own work in this, your second year. The experience in all the law schools in the country runs clean and sharp to this: that the first semester of the second year is a slough of despond and a swamp of disaster. For most of you, the edge has been taken off ambition. For one thing, the job is no longer new and strange. That is more comfortable, but it spells less drive. You will no longer be running like mad in pure fear that you may be getting nowhere. Examinations may worry, but they no longer terrify. You know what they are like. You relegate the thought of them to certain hectic weeks which still lie far ahead. Nor is there heavy pressure on your back from day to day. You have learned the more elementary workings of the ropes. Not that you have learned all there is to know of reading cases. By no means that. But you have learned enough to lodge a fine fat cushion between yourselves and any effort to induce you to learn more. Even those of you who have not learned to read cases have learned at least the art of stalling through a recitation. You have acquired the technique, let us say, of breezing through the cases in the assignment, underlining the statement of a fact or two, marking question in the margin at an appropriate passage, and spotting the 3 lines in the opinion which look as if they would do for a statement of the so-called rule. Thus fortified, and calm in your knowledge that instructors too are pressed for time, you can take on, if called upon, what may with charity be deemed a statement of the case, eyes shooting rapidly from line to line for further facts and scraps of argument. yet without altering the friendly flavors of your bedside manner. The wiser of you have learned to pay attention, strict attention, in the classroom, to take careful notes, learn to suck up each last drop of a summary. O parched throat in the desert, O oasis, that all saves time for bridge, for petting, or for penny pitching. Demands have meanwhile come upon your time. If you are here from out of town, you have local connections now. And there may even be a girl. If you belong locally, you are now dropping back into the good old whirl from which you set your jaw to break away this time last year. So comes the pressure to reduce the working week to the legal limit of hours for industry, say 54. The union hours down to 45. To the stenographer's delight, and down to 40. And down to 30, down to 25. Down to a Tarkington at 17. The job, I say, becomes no longer new and strange, nor is it still as interesting as it was. You know the motions now. If you are really good, you know them well. What once was high excitement, an intellectual game, is turning to routine. What once was a search for a new light has become a squirrel job, the gathering of nuts against the days in June. The instructor still summarizes, bless him. There is still good ink in the fountain pen. So less time on the cases, more on the instructor. Less interest in law, and more in what he is likely to expect on the exam. You are caught, my friends, in the machine of legal education. Your eyes dull to its pounding. You lose perspective. You have forgotten what the game is all about. So the machine will dump you shortly in the swamp. Far be it from me to decry the study of machinery. Watch your instructor. Note his weaknesses, his hobbies. Diagnose his legal and non-legal prejudices. Predict his questions. Play him for an A. That is good sense. That is good realism. That, too, is training in the law. So must you one day diagnose a court. Study the technique of case method. Build up your shortcuts. Economize your work. Save all the time you can. Naught could be better. So must you someday organize an office and a job. But do not let these matters rob you of your education. You are about to throw another year of time upon the counter. Do you want nothing for it but a stick of Wrigley's or a good cigar? You have now left behind the only period in which there was excuse for automatic, for machine-like teaching. You have graduated from the awkward squad, from the fixed drill of a first year that was needed to instill techniques no man can get along in law without. That grind is over. Now education can begin. And I am talking to you because we find so seldom. We of the teaching staff, we find so seldom that education does begin. Come with me to the mountain top. Look out over the kingdoms of this world, and let me tempt you. What are you here for? Where are you going? Wherein does this year differ from the last? The benefits of case method study you have seen, you have absorbed. Much is to be absorbed still, but more slowly now, more repetition, less new income from your work. The point of maximum return has passed. Partly the benefits have turned upon the concrete case, the driving home of every rule, every distinction in the meaning of every rule, and every distinction in terms of hard, sharp fact. Partly they go to intense, sustained analysis of finer points, and to nice reading. There you have much to do still, but the techniques you know. You need their chiefly practice. Meantime, however, two things should be growing clear to you. Knowledge, brute knowledge, is bought in case classes at a huge expense in time. Are you going to take on no knowledge cargo, except at that expense? Are you going to rest for 2 more full years upon the case book and the instructor's summary? Will you let the library lie fallow and twiddle idle thumbs among the daisies? Out of the deeps we cry our culpa me, culpa maxima me, our guilt. Our very guilt it is that tempts you to the twiddling. We have learned so relatively well how to do one kind of teaching that we sit Narcissus-like before the pool. We go on teaching cases and do too little teaching else. Well then, so be it. But is your instructor's blindness to obscure your vision? There is this other fact about case teaching which should be growing clear to you. Intensive, sustained analysis and group discussion must presuppose a very narrow, common subject matter. Narrow and common, and hence of necessity assigned. Thus the very precondition of case discussion lames initiative. Thus, in acquiring this best of techniques, you fall into the worst of study habits. You find yourselves already knee-deep in the swamp. That it is time to change. Now is the time to change it. Case teaching is graduate teaching in its training and analysis. It calls for ripe powers. It calls for a ripe attention span. It calls for ripe depth of thought. But it is grade school teaching in its method of assigning stuff. You have your training for professional careers at stake. It is time to begin to act accordingly. I am suspicious of comparison between the disciplines, more especially so of those I have most often met with, those between law and social science. There are so many men, so many books, so many theories loose in each. Each in itself is so bewilderingly uneven. If you are conservative, then you look to the fine peaks on your own side of the border and challenge the plains across the way to a comparison. If you are fond for new things, you see the peaks across the way and conclude from them to mighty tablelands. So here, the best of graduate students, say in economics, learn in 3 years an independence of investigation, a hunger for wide reading in their fields, which few of our men find. Yet for the ruck, our case teaching seems to me a vastly better teaching engine than their lectures. But to judge their study by the lectures is to miss the real meat of their training. To judge our study by our case classes, can you say the same? The matter comes down, then, to this. Do you propose to be bound by the limitations of our method and of your own sweet urge for ease? And if not, I shall assume not. I shall assume you have interest in what optimists would know as your career. I shall assume that independent effort is beyond neither your powers nor your desires. I am not content to take for granted that you are children who must eternally be handed out a daily task. Indeed, to my mind, I have a duty to make these assumptions. For of all professions, surely there is none of which responsibility is more strikingly characteristic than it is of the law. You are to go out to handle business, not of your own, but of your clients. You are to go out equipped to stand on your own 2 feet, and then to shoulder others' burdens. You are to go out fit to be trusted by men who do not themselves know what they want. A schooling which takes responsibility off your shoulders is no schooling for that job. If sloth and dalliance are too much for you now, unless the schoolmaster's whip is snapping on your neck, then turn to something you can do well, while there is time. If foremen are your need, get under one. What, then, do you need that we do not offer you, and how can you set about getting it? It is hard to answer that question. It is hard, first, because my own eyes are still muffled in tradition. On case teaching I was raised, and by it I have earned my living these 12 years. It is hard, second, because we still know so little of what constitutes the practice of the law today. How much of the old-time practice has been taken over by trust and title companies, and how many lawyers do they use? How much of their law is in the cases on the statute books? How much is based upon their own practices and understandings? How much of law practice lies in trial of cases? And with what differences between New York and Wichita and Cedar Forks? How does trial practice in the city court differ from trial practice before the federal courts or the Supreme? Where does appeal work fit into the picture? How much of practice lies in interviews with the dock commissioner or the tax commissioner or the claim agent for the New York Central? Is there a special workman's compensation bar? How much of law practice lies in drafting contracts? How much in closing titles? How much lies in dispossessing tenants? How much in business strategy? How much in journeying to Albany or Washington to lobby? How much of the lobbying occurs when the committee has adjourned? How much of practice lies in getting business, and whose business, and how is it got? How much of practice lies in marrying the senior partner's niece, and which of them, and again, how? To these and to some 100 other questions we can answer. For some men, more or wholly. For some, less or not at all. For how many or how much for any, we can only guess. And which of these questions is later to concern particular ones of you, that is not worth guessing at, so that it is hard to answer the question, what do you need? Still harder, because different ones of you have different needs, even if you were all to come out at the same place. The best I can do is to put before you some of the things that every lawyer, or almost every lawyer is sure to need, but which case study does not offer. I have picked very few, and those few I have chosen conservatively practically. I have chosen them on the technical side. There will still be more of them than any individual can hope to do much with. But it is time you did some conscious choosing about your training for a profession, for which no school I have yet learned of offers in its curriculum more than a first aid in case of sunstroke sort of training. In 3 points, you can profit by the example of the law review. I have said this to you before. It bears repeating. The law review is, to an insignificant degree, a mark of merit for the editor. It shows, to a quite insignificant degree, that someone thinks him good. But in its essence, law review editorship is an opportunity, and not a badge. In its essence, law review editorship has value not for what it took to get on, but for what the editor learns because he has got on. What the law review offers, and the only thing it offers, is a machine geared, set up, waiting, into whose maw the editor is cast, and which we know that we can trust to educate him. And the advantage of law review men in getting jobs comes not because they come certified as having made the grade initially, but because they come certified as having had, and been capable of using, the best education that the school has thus far offered. That education, in the qualities which make it best, lie, as you know, outside of the curriculum entirely. The law review men, in a word, have set themselves to do their job despite the faculty. The law review men have met the challenge of their education fairly. They undertake their training for themselves. The training lies first in the group spirit, the group work, the group discussion about law school, about review problems, about class problems, which are the essence of the law review. Interchange of ideas, fertilization of ideas, self-clarification by attempting to make clear to someone else, training by having a point to fight and by fighting it. And these are aspects which any man can have, on the review or off, who gets together consistently over the law with a body of his fellows, who gets together with them, not alone before exams, but regularly, weekly, daily, who will set up his own machine. A lone wolf in law school is either a genius or an idiot. The pickle solution that turns watermelon rind into an ornament to any table can turn a seeming dud into a useful lawyer. But the process of soaking must be continuous, and it must last. Nor does the value of group work lie in the presence of the soi-disant self-proclaimed superior minds. If your neighbor is dumb, you learn in teaching him. If he is slow, you think your problems through more deeply. If he is fast, he stretches you to keep pace. But you may find flaws in his thought, which he has overlooked. The second advantage of law review education lies in the editor's learning to do research on his own, to diagnose a problem, to size it up, to locate relevant material, to analyze it, to reject the worse of what he finds in favor of the better. And that is hard, that scrapping of hard labor, and then to put together again. To criticize, and then to build. It is not enough to know how to find relevant data. One must gain patience to find all the relevant data, then to discard the less relevant. It is not enough to find them. One must work them over, weave them into a whole. It is not enough to make a pile. There is a building to be made. This is of the essence of any analysis or solution of a problem in the office. It is not all of such analysis, much less all of such solution. But it is a vital part. And it is a part which case class study never gives per se. Even if you really put your notes together and gain some skill in synthesis, you miss the learning from research. And the third aspect of the law review education is that the editor learns to write. He becomes, gentlemen, legally literate. I beg your attention to this fact. For if we had a legal Army alpha test, most of you would not now rate as eligible to take it. For you the beta test, the test for men who hardly read and do not write. Yet half of a lawyer's work consists in writing. There is the writing which leaps into your mind, the writing of an argument. Where do you learn that now? In the examination you are too hurried to think how to write an argument. In your oral speech, you give no thought to form, little to order. In your moot court brief, you have no pressure toward economy of words. The essence of learning to write an argument is the limitation that the law review imposes. You have to be brief, therefore, if you are to get anything across, you must clarify the course of argument. Each point must prepare the point to follow. The fourth point must follow of itself from the first three. You have to be brief. Therefore, you must clarify the presuppositions of your argument. You have to be brief. Therefore, you must find the one word that does the work of 10. And the law review man learns too, that most useful of lawyers' arts, argumentative exposition. The statement of a case, the arrangement of facts, the stress in presentation, which argues without argument, the desired conclusion. Two other types of lawyers writing, to be sure, he does not learn. The one is drafting, whether it be lease or contract, testament or statute. The art, given the law, given the situation, given the prejudices, desires, needs of one party or of two, of planning and wording a document which charts a safe course and steers it cleanly then as charted. The other is the negotiating letter, that combination of drafting and persuasion, in which you save and strengthen your position, while trying at the same time to sell your own desires to your adversary. I go into these aspects of education on the Law Review in such detail, because I am sick to nausea of the gutlessness that second-year classes have displayed these many years. Some who had hoped election, peeved, sneering, childishly aloof from law review and school and work, and all to comfort an injured vanity by scorn of the work their own careers will need. More, many more, the most, lined up and bowing, stooping a supple back to slide onto the review men, all leadership in class discussion, supine, assuming that since theirs is not the greatness, neither is it theirs to break in upon the close monopoly of better education. Taking as a sign of greatness, as a stamp of leadership, the accident of opportunity. To the review men, this idolization doubtless does no heavy harm. The swelled head is no serious danger so long as review tradition and the revising editor will put on the screws, will keep up the speed, so long as prestige means sweat, means steady sweating. But for the class at large, I say it is abominable. What these review men get in education is yours too, for the taking. They have indeed the numbered places at the trough, reserved and waiting. But there is trough enough for all. The trough is free. Let the review men profit by it, while you go without, and editorship indeed means he is better. A fatter pig, a bigger pig, a stronger pig, a quicker. Better indeed. Better, because he has become so, because he has made himself so. But not if you turn to now to keep the balance even. There are 20 men in the class who can hold their own with most of the review. There are 50 others who stand fair chances of still reaching the first group. There is not one whose education will not double or treble in its value, if he breaks loose from following in the wake of constituted authority. If he knocks the halo off the classroom and sets about to get some training on his own. You are a queer lot, in your intellectual inconsistencies. Our gods you scorn. You turn bold eyes into the green-white light of disillusion. You learn and accept from us some disillusion in the law. So far the image breakers, the scornful of idols, the sophisticates. Yet at the same time you labor building new images, walking in awe and self-abasement round before their sightless eyes. You have stripped the pedagogue of his glory. He is a naked insect under your glass. You view him realistically, a problem in examination setting to be reckoned with. I do not quarrel with this. It is most wholesome for the pedagogue. But what some downtown lawyer happens to have said about the law is golden in your ears, sings its far magic like the sweet bell of Usield. And that devil-doctored shamanistic mark of school and intellectual prestige, the law review, at that you look and tremble. To cover quickly, the bull-roarer comes. I say you are a queer lot, O my children. Do you not fathom that the only purpose of all disillusion is to make you free? The road to freedom, in this instance, leads in one way only. To set a problem for yourself and go after it. If your imagination fails, there are advance sheets. I have heard, even, of instructors who left problems with the class. More, your faculty are affording definite opportunity. The outside paper sets a framework for research, for synthesis, for argument. If you will hold down your words, if you will rewrite, let it grow cold, recast your argument, rewrite again, You may in the process of one paper gain some literacy. As for group building, literate or not, you still have tongues. There are 3 things more which I would call to your attention. One is that when you practice, you will deal chiefly with one state, with one law of but one state. You know this. Stop a while and realize it. There are statutes in that state. There are decisions. There are judges. There is political organization. There are people. Those statutes, those decisions, those judges, those politics, those people, these concern you deeply. If you have not set about to study all of them and their interrelations, it is time you did. A little time each week, making your own notes. Each week. But cumulatively. Think about that. Then do it. Another is that you have soaked enough in the undiluted vinegar of law school law. It is time to spice the pickle with some background stuff. What I care little. Biographies of lawyers or of judges, together with some history of their times. The practices of the Constitution in relation to its words. The records of some cases in relation to the opinion. Visits to the courts, all courts, any courts, not as spectators, but as students and as critics. The workings of the labor injunction or the juvenile court, as shown in current studies. The Federal Reserve Board and the October market. Civil procedure on the continent. The logic of the logicians in its relation to the argumentation in opinions. The new encyclopedia of social science. What I say, I care little, but something you can bring to bear upon your law school law. Something you will bring to bear upon your law. Something you seek yourself, to make your law school law more human, to give it a broader base, a richer soil, a finer flower. And finally, I would say a word of your instructors. One effect of the first, the plastic year, upon your minds, has almost inevitably been to fit you with a set of ideas as to what types of teaching, what types of instructor are proper, are fitting to a law school. Yet simultaneously to make you passively receptive, even to these. Thank fortune, you are yet to meet with others who are vastly different. It would be sad if you were not. In meeting the others, however, you can meet them in cooperation or in antagonism. If the latter, it will cost you and the instructor 4 to 8 weeks in merely getting underway. In meeting men with new methods, you can come set to take just what you are accustomed to, and nothing else, by God, no, nothing else. Or else you can come set to find out what those men may have to give. And in re-meeting your old may I call them friends? You will tend strongly to be, more passive than before. Their bag of tricks you know, and how to rest between whiles. But why content yourselves with the knowing? Why let them palm off on you canned stuff they happen to have stored upon the shelf? Do you prefer it canned? Of course, can opening is easiest for the instructor. You sit back, and he will pour it out. Thick, with a little pepper, and devoid of vitamins. Thick, it runs slowly enough for you to take it down. He likes it, the instructor. There is a sure aesthetic thrill in skillful pouring. There is a pleasure in a skillful job. There is even pleasure in observing your hungry faces as you lap it up. Of course, you could have it better in the library. Better and faster. With more case references. A wider body of material at one time. Much quicker work. Much cheaper. More effective. And your class hours free to get your own perplexing problems solved. For no instructor is wedded to the can. There is no stimulus to him like that of an eager class. If you react, instead of sitting there like lumps of mud, then so will he. What he wants most, almost the only thing he wants, is to see some results. You give him none, and he must build his own, and hence the can. But in the measure of your expectations, in the measure that you make your expectations felt, in the measure that your minds react to his and show reaction, you will unchain the best he has to give. You will unchain stuff better than he knew he had. Bring out your questions, push for answers, follow his arguments through, and test and challenge. If not in class, because the discussion turns to another theme, then after. You are not reaching what is here for you unless your personal problem comes to its solution. There is a false pride abroad, a diffidence at taking up instructor's time. What vagrant idiocy! Let him protect himself. Keep after him. Why do you think he has an office in the building? I do not mean with every petty point. I urge group building, group jawing, group rowing, because in the groups so many problems work, all by themselves to their solution. But if they do not, come group-wise to your man. One man he may turn down. 5 he will always talk to. Have I, then, said too much? I said, a fool false pride at taking up instructor's time. And as to that I still say, stamp it out. But there are those of you who feel some hesitance, and for a finer reason. You recognize that before each of the teaching staff there floats a dream, a reputation as a scholar, to win or to sustain. You feel compunction then at breaking in upon his work. And this is good. Yet still I say let him protect himself. And still I say, there is no stimulus like that of eager students, if you come not to milk him like a cow, but for help in a problem you have struggled with, and hard, then what you bring is worth the time you cost. There is a further, final reason why it behooves you to take on for yourselves this job of education, a reason which at the end of the drill year a man should ponder long. It is the stupendous inadequacy, the lack of direction, the inefficiency in legal education. Legal education at large, not education here peculiarly. Here, as it seems to me, things are better than elsewhere. Certainly, they are nowhere better than here. Which is, in one sense, to declare a whole profession bankrupt. What has been said sketches the lines of my thinking on this point. We have but the slightest inkling of whether we should take you. We have but one vehicle worked out to take you anywhere, and that vehicle, unaltered, passes its point of maximum return before the journey is half done. Our teaching technique we have learned one by one in the helter-skelter grab bag of experience, and have carried for the most part unaltered into wholly changed conditions as to size, as to makeup of class, as to material taught. Our machinery for checking our results with you would set an intelligent ass to braying. I say that as a profession we are bankrupt. We are called upon daily to deliver what we have not got. We cannot pay our obligations as they now mature. Bankrupt if you are to judge our work by the standards of a decent engineer, or even of a decent businessman, or of the Sales Act. But from another angle, things are not so bad. We are as well off as the law itself, which is our subject of instruction. Perhaps, indeed, we are better off. We are as well off, or nearly, as most types of educators. As human institutions go, peculiarly those institutions on the social side, we can stand the current lax test of solvency. We can go on. We can do more. Nay, we are doing more. For we have awakened to the need of doing better. We are awake even to the intense difficulty of finding out how to do better. Meantime, there is no better place for you to go. That is a reason for your staying with the job, as given here. But surely it is no reason for you to rest content with that job, to turn up in it, to take what happens to be given as all that can be got. If vegetate you must, be an aspiring vegetable. Be a bean and climb.